Question 1. Attempt any 5. A. Define penalties. The term penalties refer to punishments or consequences imposed for breaking rules, laws, or agreements. Penalties are used to discourage undesirable behavior and enforce compliance in various contexts. For example, legal or criminal law, a penalty can be fine, imprisonment, or community service for violating a law. Sports, a penalty is a sanction or disadvantage given to a player or team for breaking the rule, such as a foul or time penalty. 3. Business contract. A penalty might be a financial charge or loss of right for failing to meet contractual obligation like missing a payment deadline. B. Define WIPO treaties. WIPO treaties are international agreements created by the World Intellectual Property Organization to ensure the protection of intellectual property like patent, trademark, and copyrights across member countries. These treaties help creators and inventors secure their rights globally by setting common legal standards. Key examples include the Berne Convention for Copyright, the Paris Convention for Industrial Property, and the Patent Cooperation Treaty for international patent filing. C. What is electronic signature? An electronic signature is a digital representation of a person's handwritten signature or a unique identifier that is used to sign electronic documents, authenticate the signer's identity, and indicate their intent to agree to the content of the document. Electronic signatures can take various forms including scanned image of handwritten signature, digital signature generated using cryptographic technique, or typed names, symbols, or codes. D. What is e-commerce? E-commerce is buying and selling of goods and services over the internet. It is a rapidly growing sector for the global economy, and it is estimated that e-commerce sales reached at 4.9 trillion by 2021. E. Right importance of IT Act. The Information Technology Act 2000 is crucial for governing digital activities in India. It provides a legal framework for electronic transactions, cyber security, and cyber crime prevention. The Act ensures the validity of digital signatures, protects sensitive data, and punishes cyber offenses like hacking, identity theft, and online fraud. It plays a key role in promoting safe and reliable use of technology in business, communication, and governance. F. Define EDI. EDI, Electronic Data Interchange, is the computer-to-computer exchange of business documents in a standard electronic format between organizations. Instead of using paper, fax, or email, EDI allow company to send documents like purchase order, invoices, and shipping notices directly between their computer system, saving time and reducing error. It's commonly used in industries like retail, logistics, and manufacturing to streamline business operations. G. Right working of Cyber Appellate Tribunal. The Cyber Appellate Tribunal was established under the Information Technology Act 2000 to hear appeals against order passed by adjudicating officer in cybercrime and data protection cases. How it works. 1. Filing an appeal. If any person is aggrieved by the decision of an adjudicating officer in cases like cyber fraud, hacking, data breaches, they could file an appeal with the Cyber Appellate Tribunal within 45 days. 2. Hearing and processing. The tribunal followed a quasi-judicial process where both parties were heard, evidence was examined, and legal arguments were considered. 3. Decision and order. The tribunal had the power to confirm, modify, and set aside the order of adjudicating officer. 4. Further appeal. If not satisfied with the tribunal's decision, a person could further appeal to the High Court within 60 days. Define cyber regulations. Cyber regulation refer to the laws, rules, policies that govern the use of the internet, digital communication, and information technology. It aims to ensure safe, legal, and ethical use of cyberspace by preventing cybercrime, protecting data privacy, securing network, and regulating online activities. In India, The Information Technology Act 2000 is the primary law for cyber regulation. Question 2a. Explain cloud computing and law. Cloud computing is a paradigm that involves delivering various computing services over the internet on a pay-per-use basis, enabling users to access resources such as storage, processing power, applications, and database from remote server managed by third-party service provider. Cloud computing offers several benefits including scalability, flexibility, cost efficiency, and accessibility, but it also raises legal and regulatory challenges, particularly in the context of cyber law. 1. Data protection and privacy. Cloud computing involves storing and processing sensitive data on third-party server located in different jurisdictions, raising concern about data protection, privacy, and compliance with data protection law. Cyber laws and regulations such as the General Data Protection Regulation in the European Union or the Health Insurance Portability and Accountability Act in the United States impose obligations on cloud service provider to protect the confidentiality, integrity, and security of personal data and ensure compliance with legal requirements regarding data processing, storage, and transfer. Second, security and cybercrime. Cloud computing introduces new security risks and vulnerabilities including data breaches, unauthorized access, insider threat, malware attack, denial of service attack. Cyber laws and regulations mandate cloud service providers to implement appropriate security measures such as encryption, access control, authentication mechanism, and intrusion detection system to protect cloud-based infrastructure, application, and data from cyber threat and attack. In the event of security incident or data breach, cyber law may require cloud service provider to notify affected user, government authorities, or regulatory bodies and take remedial action to mitigate the impact on the breach and prevent future incident. 3. Jurisdiction and legal compliance. Cloud computing involves the processing and storage of data across multiple jurisdictions, complicating legal issues related to jurisdictional authority. Legal jurisdiction and cross-border data transfer. Cyber law and regulation govern the cross-border transfer of data and require cloud service provider to comply with applicable laws and regulations. In the jurisdictions where they operate or provide may include provision addressing jurisdictional issues, legal compliance requirement, dispute resolution mechanism, and applicable law governing the relationship between cloud service provider and user. Intellectual property right. Cloud computing involve and creation, storage, and distribution of digital content and intellectual property asset, raising legal issues related to copyright, trademarks, patents, and trade secret. Cyber laws protect intellectual property right, trademarks, patents, and trade secret. Cyber law protect intellectual property right in cloud environment and impose obligation on cloud service provider to protect and enforce the intellectual property right of content creator, copyright owner, and intellectual property holder. Cloud service agreement may include provision addressing intellectual property right, licensing term, usage restriction, and enforcement mechanism to prevent infringement and authorized use of intellectual property asset in the cloud. 5. Contractual and liability issues. Cloud computing involves contractual relationship between cloud service provider and user, governed by service agreement, term of service, service legal agreement. Cyber law define the right, duties, and liabilities of parties in cloud computing transaction and establish legal framework for dispute resolution, breach of contract, liability allocation, and identification. Cloud service agreement may include clauses addressing liability limitations, obligation, data ownership, data sovereignty, and legal remedies available to parties in the event of contractual dispute or breaches. In summary, cloud computing intersect with various aspects of cyber law, including data protection, privacy, security, jurisdiction, legal compliance, contractual property right, contractual issue, liability consideration. As cloud computing continues to evolve and expand, it is essential for stakeholders to understand the legal and regulatory implications of cloud-based services and ensure compliance with applicable cyber laws and regulations to mitigate risk and protect the interest of user, organization and society. Question 2b. Explain penalties offenses under IT Act 2000. The Information Technology Act 2000 is a key legislation in India that provides legal recognition for electronic transaction and deals with cybercrime and electronic commerce. It outlines various offenses and associated penalties to protect individuals, organizations, and governments from cyber threats. Main offenses and penalties. 1. Hacking. Section 66. Gaining unauthorized access to a computer system and causing harm. Penalty up to 3 years jail plus rupees 5 lakh fine. Second, identity theft. Section 66C. Using someone else's password, digital signature or other identification information. Penalty up to 3 years jail and rupees 1 lakh fine. 3. Cyber cheating. Section 66D. Cheating people through fake email, website or messages. Penalty up to 3 years jail and plus rupees 1 lakh fine. 4. Data theft, unauthorized access. Section 43. Copying, downloading and altering someone's data without permission. Penalty, compensation up to rupees 1 crore, civil offence. 5. Child pornography. Section 67B. Viewing, sharing or promoting content involving minors. Penalty for the offence 5 year jail and 10 lakh rupees. Fine for first time and 7 year for repeat offence. Civil cases like data loss handled by adjudicating officer and larger offences or appeals go to Cyber Appellate Tribunal, now TDSAT. Question 2c. Explain various authorities under IT Act and their power. The Information Technology Act 2000 establishes several authorities to regulate digital transaction, prevent cybercrime and ensure cybersecurity in India. Key authorities and their powers are 1. Controller of Certifying Authorities, appointed by the government to regulate certifying authorities, issues licenses, sets standard for digital signature and can suspend or revoke CA licenses. 2nd. Certifying authorities authorizes to issue digital signature certificate, verify applicants and maintain security for issuing reliable certificate. 3. Adjudicating officer, appointed to settle civil dispute involving cyber contraventions up to rupees 5 crore, has power like a civil court, can summon parties, examine evidence and impose penalties. 4. Cyber Appellate Tribunal, heard appeal against order or adjudicating officer, could confirm, modify or overturn decision. Appeals from here went to the High Court. CERT, in Indian Computer Emergency Response Team, nodal agency for cybersecurity incident, issues alerts, advisories, coordinates responses to cyber threat and can demand information from companies. These authorities ensure lawful use of technology, resolve disputes and strengthen cybersecurity in the country. Question 3a. Explain domain name and trademark dispute with suitable example. A domain name is an alphanumeric address used to identify a website on the internet. For example, www.example.com. A trademark, on the other hand, is a distinctive sign used to identify and distinguish the goods or services of an entity from other. It can be a word, logo, slogan, or other identifier that is registered with the government to protect the brand. The relationship between domain name and trademark has become increasingly important as businesses and individuals rely heavily on the internet for commerce, marketing, and communication. A domain name and trademark dispute occur when the use of domain name conflict with the existing trademark, leading issues like confusion, infringement, or unfair competition. Types of domain name and trademark dispute. 1. Cyber squatting. Cyber squatting occurs when a individual or entity register a domain name identical or similar to a well-known trademark with the intent to sell the domain to the trademark owner at an inflated price. This practice is illegal under the Anti-Cyber Squatting Consumer Protection Act in the United States and similar laws in other jurisdictions. Example, if someone registered www.coca-cola-online.com, the individual is engaging in cyber squatting because Coca-Cola is a well-known trademark and the domain name could mislead customer into believing the website is an official Coca-Cola site. The cyber squatter could then attempt to sell the domain name to Coca-Cola for a higher price. Second, domain name infringement. A domain name may infringe on a trademark if it is similar or identical to the trademark of a well-known company or product, leading to consumer confusion. Even if there is no bad faith intention or profit from trademark, the domain name could still cause confusion about the origin of the services or product offered on the website. A company name Reebok Shoes register the domain www.reebokshoes.com. Since Reebok is a globally recognized trademark for footwear and sport apparel, this domain name could confuse consumer into believing that it is official Reebok website, potentially infringing upon Reebok's trademark right. 3. Bad faith registration. This refers to registering a domain name with a intention of misleading user, creating confusion or harming the business of trademark holder. This can happen even if there is no direct attempt to sell to domain trademark holder, but rather an intent to benefit from the reputation of trademark. Example, if someone registered a domain www.mcdonaldburger.com is an effort to deceive customer into thinking they are visiting an official McDonald's website. This would be a case of bad faith registration because the domain name take advantage of McDonald's well-known brand to attract traffic or mislead user. Domain name and trademark dispute have become a major issue as the internet has expanded. While domain names are essential for online businesses, the misuse of these names in a way that infringe upon trademarks can cause significant harm to the brand owner and mislead consumer. Legal framework like the UDRP, national laws and court remedies are in place to protect trademark holder from bad faith registration and cyber squatting, ensuring that domain name and trademarks are used appropriately and in accordance with the law. Question 3b. Explain copyright in computer programs with suitable example. Copyright is a legal protection granted to the creator of original work, including literary, artistic, musical, and dramatic work. In the context of computer program, copyright provides legal protection to the source code and object code of software program, treating them as a form of literary work. Under the Indian copyright law and international agreements such as a Berne Convention, computer programs are protected by copyright, ensuring that their creator or owner have exclusive right to use, reproduce, distribute, or adopt the program. Rights of the copyright holder. The copyright holder of a computer program has the exclusive right to reproduce, make copies of the program, distribute, sell, lease, or give the program to others, adapt, modify, or create derivative work based on the original program, public performance, display or execute the program on a public setting. These rights are critical to preventing unauthorized copying, distribution, or modification of software, which could lead to piracy or infringement of the creator's intellectual property. Exceptions and fair use of computer program. While copyright law grants strong protection to computer program, it also allows for certain exceptions, including 1. Reverse engineering interoperability. In some cases, reverse engineering a program to achieve interoperability with other software may be allowed under certain jurisdiction, provided it is done without infringing on the program's source code or object code. Example, if a developer needs to create software that can work with an existing application like a plugin for a popular music player, they may reverse engineer part of the program to understand how it interacts with other software. Second, fair use. Certain use of copyright computer program like research, criticism, non-commercial educational use may be allowed under fair use provision, although this varies by country. Example, a student analyzing the functionality of an open source program for a project could be considered fair use. Infringement of copyright in computer program. When someone use, reproduce or distribute a copyrighted program without authorization, it constitutes copyright infringement. This could involve piracy, the authorized copying and distribution of software. Using cracked version. Using a version of software that has been modified to bypass security feature like licensing. Copying code. Copying portions of source code from another program without permission. In Microsoft versus Software License Compliance, Microsoft sued an individual for using pirated version of its software. This defendant was found guilty of violating Microsoft's copyright, which led to both a monetary settlement and the enforcement of stronger licensing measure. Copyright provides strong legal protection for computer program, covering everything from source code to the user interface. It grants creator exclusive right to their work, preventing unauthorized reproduction, distribution, and modification. However, certain exceptions such as a reverse engineering for interoperability and fair use allow for limited flexibility in specific circumstances. As technology continues to evolve, copyright law play a crucial role in ensuring that software developer can protect their innovation and maintain control over their intellectual property. Question 4a. Describe in brief international perspective cloud computing and law applicable to SPDI. Many countries have enacted data protection laws to safeguard personal information in the digital age. Key example: GDPR, European Union, emphasize user consent, data right and strict penalties. CCPA, California, USA, gives consumer control over how their data is collected and used. These laws focus on privacy, security, and accountability in data handling. Cloud computing involves delivering data storage and services over the internet. Legal challenges include data location and jurisdiction. Knowing where data is stored, data ownership, who control and own the stored data, security and compliance. Ensuring data is protected and meets legal standard, clear contract and security policies are essential to address these issues. Law applicable to SPDI in India. Under the IT Act 2000 and IT Rules 2011, SPDI include password, financial detail, health record, biometric data, etc. Key legal requirement: obtain consent before collecting sensitive personal data information, provide a privacy policy, implement reasonable security practices, and if organizations fail to protect SBDI, they may be held liable and required to pay compensation under Section 43A. Question 4b. What are the differences between copyright and trademark protection? Nature of protection. Copyright protect original work of authorship such as a literary, artistic, musical and dramatic work. Trademark nature of protection protect identifiers like word, logos, symbol, other mark that distinguish goods or services. Copyright, what is protected? Literary work, books, article, artistic work, painting, sculptures, software, music, photographs and films. Trademark. Trademark protects names, logo, slogan, symbol and other distinctive brand identifiers used in commerce. Registration of copyright is automatic upon creation but can be formally registered for additional legal benefit. Trademark registration must be registered under with the legal relevant intellectual property office for fully legal protection. Duration of protection. Copyright typically lasts for lifetime of the author plus 50 to 70 years after which it enters the public domain. Trademark can last indefinitely as long as the trademark is in use and renewed periodically, typically every 10 years. Purpose of copyright. Copyright protect creative expression and the right of the creator. Trademark protect brand identity to prevent consumer confusion and maintain a company's reputation. Rights reserved. Copyright exclusive right to reproduce, distribute, perform, display, create, derivative work of the original work. Trademark exclusive right to use the trademark in commerce and prevent others from using confusingly similar marks. Infringement consequences. Legal action can result in a statutory damage, injunction, and compensation in copyright. Trademark legal action can result in injunction, damage, and destruction of infringing goods. Example of copyright: books, movies, software, music, album, and paintings. Trademark example: Apple logo, McDonald's, Golden Ark, Coca-Cola. Question 5a. Explain the digital signature need and scope. The digital signature is a cryptographic technique used to authenticate the identity of signer and ensure the integrity of electronic document and transaction in the digital realm. Digital signature play a crucial role in various domains including electronic commerce, electronic governance, online communication, and legal transactions by providing secure and reliable mechanism for verifying the authenticity of digital content and the identity of parties involved in electronic transaction. The scope of digital signature encompasses: 1. Authentication. Digital signature verify the identity of the signer and the ensure sender of digital document or message is who they claim to be. By using cryptographic algorithm, digital signature create a unique digital fingerprint or hash of the document that can be verified by receptionist or third parties to confirm the authenticity of the sender. Second, integrity. Digital signature ensure the integrity of electronic document by detecting any unauthorized alterations or tampering during transmission or storage. The digital signature is a link to the content of the document and charge if any modification are made, thereby providing assurance that the document has not been altered since it was signed. 3. Non-repudiation. Digital signature provide non-repudiation, meaning that the signer cannot later deny having signed the document or message. Digital signature generate a cryptographic proof of the signer's intent to sign, which can be used as evidence in legal proceeding or dispute resolution to establish the authenticity and validity of electronic transaction. Legal validity. Digital signature are legally recognized, the enforceable in many jurisdictions around the world, including India and European Union, the United States. Various laws, regulation, and international standard govern the use of digital signature and provide a legal framework for electronic transaction, contract, and agreements signed using digital signature. The need for digital signature arises from the growing reliance on electronic communication, transaction, and document management. In today's digital economy, key reasons for the adoption of digital signature include: 1. Security. Digital signature provides strong authentication and encryption mechanism to provide electronic document and transaction from unauthorized access, tampering, or forgery. They enhance the security and confidentiality of security information and ensure that the only authorized parties can access the modified digital content. Efficiency. Digital signature streamline business processes, reduce paperwork, and estimate the need for physical signature or handwritten signature on paper document. They facilitate faster and more efficient and paperless workflow, enabling organizations to save time, reduce cost, and improve productivity in electronic transaction and documents. Compliance. Digital signature help organizations comply with digital and regulatory requirements related to electronic transaction, meet the legal standard for authenticity, integrity, and non-repetition prescribed by applicable law and regulation. Globalization. Digital signatures are essential for enhancing security, efficiency, compliance, and global connectivity in electronic communication, transaction, and document management, addressing the evolving need and challenges of the digital age. Digital signature enable secure and seamless electronic transaction across geographical boundaries and time zones. Supporting international trade, commerce and collaboration in the global marketplace, they facilitate cross-border transaction, contract and agreements without the need for physical presence or paper-based documentation, promoting business efficiency and international cooperation. Explain cyber regulation and appellate tribunal with suitable example. Cyber regulation refer to the legal framework that govern the use of information technology, digital platform and electronic transaction. These regulations aim to ensure cyber security, prevent cybercrime, protect privacy and address issues related to the internet and digital technologies. In many jurisdictions, specific law, rules and tribunals are established to regulate cyberspace activities. In India, the Information Technology Act 2000, commonly referred to as the IT Act, and related regulation from the core of the cyber security. 1. Cyber regulation. Cyber regulation are laws and rules aimed to regulate the use of cyberspace to prevent illegal activities and protect digital data. They address various aspects including cybercrime, privacy violation, e-commerce, data protection, digital signature. Key elements of cyber regulation. Cybercrime and offenses. Cybercrime include activities such as hacking, identity theft, phishing, cyber stacking, and malware distribution. Cyber regulations lay down penalties for these crimes to deter malicious activities on the internet. E-commerce and digital contract. The IT Act 2000 provides a legal framework for electronic contract and digital signature, ensuring that online transactions are legally binding and secure. Data protection and privacy. Cyber regulations also govern the collection, storage, and processing of personal data, ensuring that individual privacy rights are protected in the digital environment. Cyber security regulations often require businesses and organizations to adopt measures for securing their digital information and safeguarding users' personal and financial data from breaches and attack. Appellate Tribunal for Cyber Regulations. The Cyber Appellate Tribunal (CAT) is a specialized forum established under the Information Technology Act 2000 to handle appeals against order issued by adjudicating officer in cases of cyber-related dispute, penalties, and violations. The Cyber Appellate Tribunal is part of the regulatory system that allow affected individuals or organizations to challenge decisions regarding the cyber offenses, penalties, or the handling of electronic record. Role of Cyber Appellate Tribunal. The Cyber Appellate Tribunal is tasked with hearing and resolving dispute arising from the implementation of IT Act and associate regulations. It handles appeals from decisions made by adjudicating officers who are appointing to assess and adjudicate cases related to cybercrime, penalties, and breaches under the IT Act. The tribunal provides a platform for individuals or companies to contest order that involve issuing like cybercrime offenses, data protection violation, digital contract, or penalties imposed for violation of the IT Act. The Cyber Appellate Tribunal is headed by a chairperson and is staffed by technical member with expertise in technology, law, and cyber related matter. Example of cyber regulation and appellate tribunal case. Cyber case hacking. Situation: a hacker accessed a company's server and stole confidential data. The company reported the incident to the relevant authorities and adjudicating officer determined that the hacker should be fined for the offense. Appellate tribunal involved. The hacker appealed the decision at a cyber appellate tribunal, contesting the fine and the findings of the adjudicating officer. Outcome: the tribunal reviewed the evidence and upheld the adjudicating officer's decision, imposing a penalty as per the relevant section of the Information Technology Act. Cyber regulation play a critical role in regulating the use of technology and cyberspace by providing a legal framework to handle cybercrime, protect data privacy, secure digital transaction, ensure compliance with cyber security standard. The Cyber Appellate Tribunal serves as an essential component of this framework by offering a platform for resolving dispute related to violation under the Information Technology Act Through its decision, the tribunal helped ensure that cyber regulations are effectively enforced, that the individuals and businesses have access to a fair hearing when contesting penalties or orders.